President Trump's birthright citizenship order for the second time. The renewed decision comes after the Supreme Court barred district judges from ordering nationwide injunctions, but allowed for plaintiffs to seek class action status, which can provide the same nationwide impacts. The plaintiffs, a pregnant immigrant, immigrant parents, and their infants, requested class action status. At an hour-long hearing this morning, Judge Joseph Plante granted their request, but slightly narrowed the class to include only babies across the country who would be affected by Trump's executive order, not the parents. The administration's limitations on birthright citizenship remain in effect for 7 days, giving the government time to appeal. The verbal ruling will be followed by a written order. The Supreme Court on July 8th lifted a lower court order that prevented the Trump administration from carrying out job cuts en masse and restructuring federal agencies. Joining us now to discuss this is Bobby Ann Cox, civil rights attorney and fellow, Brownstone Institute and legal analyst. Also joining us is Dante Mills, lead attorney and managing partner, Mills Legal. He's a civil and criminal defense attorney. So good afternoon to you both. Thanks for joining us. And before we get to the main topic, I just want your comments on what I talked about earlier. A federal judge in New Hampshire blocked President Trump's executive order restricting birthright citizenship and granting a class action status to a lawsuit representing babies who would be affected by the order. So as you all know, the Supreme Court recently limited the use of nationwide injunctions, but allowed nationwide relief in class action lawsuits, right? So Bobby Ann, I'll start with you today. How easy or how difficult it is for law firms, for example, or advocacy groups to file and certify a class action lawsuit?
Well, excuse me, it really depends on the size of the class. It is very labor intensive. Generally speaking, class action lawsuits will entail hundreds, if not thousands of people as plaintiffs. But you do need a full team if you're going to be a law firm taking on a class action lawsuit like this. You need multiple attorneys, multiple paralegals, multiple legal secretaries. There is a lot of organization that goes into getting a class action lawsuit filed and fighting the suit thereon. So it is not that easy to accumulate and keep tabs on and pursue a class action lawsuit. It does take a lot of resources, but it's done. It is done absolutely, and it's done fairly often, depending on what industry you're in. So this is a case where they want to bring a class action lawsuit in this particular manner for this particular constitutional question. So we'll see if they get classification.
Okay, Dante, can we get your expert analysis as well? What factors influence whether a class action status is granted?
Absolutely. So when you're talking about a class action, what you need is plaintiffs who would have a similar interest or outcome and similar damages. So when you think of class action, people think, oh, or a bunch of people are suing the same person. That's not always the case where they qualify for a class action unless they have similar damages. For this particular purpose, it works because the damage would be you would lose your citizenship. So what they're saying is we're going to bring together everybody who would have the same damage of losing their citizenship if birthright citizenship is taken away, pull them to one class, and allow essentially one case to be worked on and determine the outcome, as opposed to having multiple cases where you could get multiple outcomes. That's what the court wants to avoid. So if, for example, every single person brought their own lawsuit, they could have different outcomes, and then you don't have kind of a guideline as to what's supposed to happen. So I do think a class action is appropriate here. Once that class action is started, you have what's called a steering committee for the plaintiffs. It's a group of attorneys who would lead that class action and put everything together. I don't think it's difficult to do. I've participated in many class actions for different reasons. I think that's the right remedy. It's going to be interesting, though, to see if the injunction is upheld, because the Supreme Court did say that they're not in favor right now of the district courts putting a halt to nationwide policies. So I think that part of it would fail, but the class action is appropriate in this case.
All right, we have limited time today, so Bobby Ann, let's get to the Supreme Court decision. What did the Supreme Court decide in the restructuring federal agencies case, and what did it not rule on?
Right. So, with this restructuring of federal agencies, what the Supreme Court has said is that the executive branch, the Trump administration, does have the authority to do this. The executive order was put on hold by the lower courts, both the trial court and the appellate court. And that was an executive order that he had issued back in February. And they had halted that and said it was not permissible unless Congress was going to allow it and certain purviews therein. But the Supreme Court has now ruled that that they are lifting that injunction. They're saying that President Trump and his administration can move forward at this time and can go ahead with their layoffs and their restructuring. But they have not ruled on the legality of how they are doing it. And in other words, they have not ruled on what the plans are to specifically do the layoffs. So they today have just said that they are going to allow this injunction or this halting of President Trump doing this, and they're going to allow that to move forward and allow the agencies and the heads of each of these agencies to go ahead and do their restructuring.
Okay, Dante, so put simply, as Bobby Ann said, it means that the administration can now basically conduct layoffs and structural changes at federal agencies immediately. Is that right?
Kind of. Structural changes is going to be an issue. So just so everybody understands the premise here, Congress has the authority to designate these different departments and create these different departments. The president does not have the authority to do that. So what the argument was is Congress set up these departments. The president can't dismantle them. Congress has to do that. The nuance, though, that the administration found is or what they said is we're not dismantling the entire department. Essentially, we're just, stripping it of most of its employees. But technically, if they leave one person there, for example, the department still exists. And that's what the court said. The district court doesn't have the authority to put that on hold because the administration can scale back that department because they have the right to determine where they want their focus to be as an administration, as long as they're not dismantling the entire department, because that is the role of Congress. So that's what you're going to see happening. The departments that this administration doesn't want, they're just going to strip them down, leave them in place technically, but there's not going to be anything happening there, and that won't be a violation of the separation of powers.
And Bobby Ann, that's exactly what Justice Ketanji Brown Jackson said in her dissent, saying that Trump's actions are unconstitutional and that, quote, over the past century, presidents who have attempted to reorganize the federal government have first obtained authorization from Congress to do so.
Right. Well, I disagree with Justice Jackson on this. Excuse me. Basically, the separation of powers is established very clearly in our Constitution. And that means that the executive branch, which is, the president is the head of the executive branch and the agencies do fall under the executive branch, that they are allowed to conduct their business as they deem fit. It is not up to the courts, whether it's the Supreme Court or lower courts thereunder. It is not up to the courts to say how the government is run, how it is structured, yes. However, not how it is run. So they can't just reach in and say that they don't like the way a president is cutting jobs or diminishing the number of employees in a particular agency. That is not something that a court can step in and do. They don't have that power. It is up to the executive, and by the executive, we are including in there the agencies and those who are running those agencies. It is up to them to decide how many employees they have, what those employees are going to be working on, and any sort of policy conditions pertaining to working for them in that agency. So I do not agree with her dissenting opinion. I do agree with the majority here that this is something that a president, head of the executive branch, does have the power to do.
Okay, Dante,
if
your
I can
response.
Just jump in, though.
Yeah, please.
Yeah, it is a kind of a cute argument to say the president or the executive branch has the ability to scale down or decide how many employees should be in each department. Essentially, what you're doing is you're bleeding into Congress's power to establish these agencies. That's not the authority or the power of the executive branch. If Congress says we need an agency to do this, to oversee this, or to control this, that's their right. But the president now and the executive branch is coming in and saying, okay, well, you have the authority to do that, but we're just going to strip it down so it's meaningless. And I don't know if that's what the when the Constitution was written, if that's what they thought would happen, where we're going to give Congress the authority to establish these agencies, but just allow the executive branch to make the agency not matter. I think that's a technicality that wasn't intended by the founders of the country. So we are going into a different area here, but clearly it fits under the law. If you say we're going to leave this administration or this department in place, we're just going to strip it down to the point that it doesn't make a difference or it's meaningless, and we're still not violating any constitutional rules.
Bobby N. Jackson saying that reduction in force actually amounts to a wholesale restructuring of the federal government.
No, absolutely not. That is the wrong reading. I just have to point out that the Constitution says that the executive branch enforces the laws, right? That the laws are passed by Congress. That's the legislature. That's the legislative branch. And the executive branch enforces the laws that are passed by Congress. Congress is not the one that comes in and says, if the Department of Education has, 50 sub-departments and 20,000 employees in each of them, it's not up to Congress to say, you have to keep 20,000 people working in each of these subdivisions of this one department. It's not how it works. It's the executive branch that gets to say, well, we need to enforce X, Y, Z laws. We need this many people to help us do that effectively. And we don't need these smaller divisions within this larger agency. That's up to the executive branch. It is not up to Congress to come in and say that. Establishing.
But that's not what's happening.
It is what's happening. It is what's happening.
They are.
All right. Let's do this one at a time. Bobby N., if you're done, Dante, please go ahead.
Yes,
I'm sorry.
you can go.
I thought you stopped talking. I apologize for talking over you. But Congress, for example, is saying we need a Department of Education. The administration is saying, I don't think so. So what we're going to do is just scale it back. And I'm going to use some exaggeration, but we're just going to make the Department of Education. We'll leave it in place, but it's just going to be one person in a basement with a stapler. That's what they're doing. That's essentially removing the Department of Education, which Congress had the authority to say was required and necessary. And that is skirting the rules. And that's what's happening here. I just don't think that that's what the Constitution intended. If they said Congress decided we need a Department of Education, then you should have a department that's actually functioning and participating in the way that education is run in the United States, not the administration being able to scale it back to the point that the Department of Education exists, but it doesn't matter or make a difference because it's been stripped of everything and all its resources.
Okay, Bobby Ann, your
Right.
response, and as well, let me ask you, why does the court feel like the government is likely to succeed in its argument that President Trump's reorganization actions are lawful?
Yes. So the Supreme Court did point that out. That's a great point there, that they did say that they think that President Trump, the executive branch, will be victorious in their arguments here. The reason that they said that is because, as I said, the Constitution is clear. The executive branch has the power to enforce our laws. And part of enforcing our laws is having these agencies to assist the executive, to assist the president in carrying out these laws. So that is clearly a presidential power. That is not a power that Congress holds. It's not a power that the judges hold either. Even the Supreme Court judges, they don't have the power to come in and say, you must keep the Department of Education. You must keep at least 50,000 employees within the Department of Education. You can't fire these people because we need a Department of Education that we, meaning the court or Congress, think is good and affecting change and getting things done. No, that is something for the president to decide. The president and then the people that he appoints to head these various agencies, they decide how many employees they need in order to properly operate whatever agency or division within an agency that they deem fit. That is not something that that Congress can decide or the judges, which is why the judges said in their opinion, that they believe that the Trump administration will be victorious on the merits of this case.
All right, we're almost out of time here, Dante. So if you have any final thoughts.
Yeah, I agree 100% with what you said. It is technically, it's correct. The Congress has the ability to establish these departments, and there is no instruction as to what exactly those departments have to include or how much staff they have to have. That is up to the executive branch, who is the one who kind of regulates that. So technically, they're right, and the Supreme Court is correct that on the black letter law that the administration will be successful. But I just think the intent of having Congress establish these departments only for the executive branch to strip them completely of all power doesn't really make sense. So while technically they're right, I think practically it's going against what the intent of the Constitution was, and the administration just found a loophole that they were able to climb through and do whatever they want, which is not really what we want to have happening.
Okay, we have to leave it there today. Dante, Bobby Ann, thank you so much.
Thank you.
Thank you.
Coming up, State Department is warning